Yes. Now, if you have to pay a motion fee, then they're not going to accept it.
Officer Day, would you open my courtroom, please?
The state of Michigan 36th District Court is now in session with the Honorable Judge David S. Robinson Jr. presiding. Court is now in session. Good morning, everyone. Good morning, Your Honor.
Good morning. All right, Ms. Ratto and Mr. Voorhees appear to be on the same file. Good morning.
Good morning, Your Honor.
I think I have a pair. You guys are both here on Shantone Davis.
That is correct, Your Honor.
All right, let's call your
Yes,
file.
Your Honor.
We are on the record calling file number 20167-382. The file is entitled Shantone Davis versus State Farm. This is the wrong file. Your respective appearances, please.
Yes. Good morning, Your Honor. Brian Voorhees appearing on behalf of plaintiff Shantone Davis, P81834.
Good morning, Your Honor. Christina Rada on behalf of defendant State Farm, P81868.
All right, this is our first pretrial, so my first question is whether you guys have made the 2.3028 disclosures.
I know plaintiff has sent theirs back in March, Your Honor.
Ms. Rado?
Yes, we sent ours just recently. You received them, Brian?
I did, yeah. I got the PIP claim file. And
Okay, so you guys got what you need.
Yes, Your Honor.
What are we arguing about here?
Yes.
Mr. Voorhees, what are we arguing about?
What are we arguing about? I don't have an argument, Your Honor.
If you didn't have an argument, the case would be settled.
Right. Obviously, I think we need just some additional discovery. I think they're going to want to take the deposition of Miss Davis. I have no objection to that. We can stipulate to that. I'm just updating bills and I'm waiting for the lien for Medicaid to get updated. So I know if there's actual.
Never know when that's going to happen. Okay, let's do this then. You guys work out between you then a stipulated date for the deposition of Ms. Davis. Let's get that in before we're together next time. Does June 22nd work for both of you for next time?
Double check my calendar. I don't see that being a problem from my end. June. That works for plaintiff, Your Honor.
Ms. Rado?
Yep, I'm just checking real quick. I'm sure that it will.
Your Honor, you did say June 22nd?
2-2.
2-2. Thank you.
Tuesday like today.
Yep, I am also available, Your Honor.
Okay, then here's what we're going to do. I hope that the disclosures have been made. Parties will do a deposition by stipulation. Our next pretrial, June 22nd at 10 a.m. Is there anything else we can accomplish today?
Not from plaintiff, Your Honor.
Ms. Rado?
I think we're all set, Your Honor.
Okay, let's get that dep in. Thank you guys for coming in. We're off the record.
Thank you, Your Honor.
Have a good day.
You too.
Thank you, Your Honor. All right, everyone have a good one.
You too.
All right, thanks.
We are on the record calling file number 20160-322, open MRI of Livonia versus Titan Insurance. This file is here for basically a scheduling conference to set up a hearing date for a motion for summary disposition. This file is also the file in which my present practice, more trees have died than any other. Your respective appearances.
Good morning, Your Honor. Harlan Beverly on behalf of the plaintiff, P44028.
And good morning, Your Honor. Catherine Rhodey on behalf of the defendant, P83529.
All right, now that you have killed all these trees, where are we on this file?
Your Honor, on this file, it looks like we just needed a hearing date. We had 2 MSDs that were filed. In this present case, there also is MSD filed in the underlying PIP case, which is in Wayne County Circuit Court. That one is scheduled to be heard on July 9th.
Well, that's not going to help me because I'm going to have this case before that.
I don't, you said there's 2 MSDs? I don't have 2. I have 1.
I have 2. They were both sent out back in April. One is the MSD based on fraud in the underlying claimant, and one is an MSD based off of a 1-year back issue. They were both mailed out at the same time.
Wait a minute. Okay, one moment. Let me see something. I might, maybe I'm in the wrong file. Give me 1 second. Is this, what is the name of the,
George Henderson's the claimant.
Yeah. Okay, hold on. No, what I have is 1 MSD that Christopher Lewicki filed. And that's for summary disposition. It appears to be, from what I read, that's the one where you're claiming fraud. And then you sent me MSD exhibits A through B, and then MSD exhibits C through G. That's the only MSD that I have.
Okay, I have a relatively short motion for summary disposition filed, looks like on or about April 7th from Christopher Lewicki. Then that has only exhibits A and B. Then there's a massive motion for summary disposition with exhibits A, B, C, D, E, F, and G.
That's the only one I have, the latter one.
Okay, you don't have the skinny one?
No.
I can resend it to you.
Okay, let's do this. I think what might make our lives a little simpler would be to bifurcate this hearing. And let's hear the 1-year back rule matter first. That one is relatively short, so you should be able to get your answer and response out to that relatively quickly. And that might even be a case that where you are in a position to just stipulate to that relief. Basically, what she's claiming is that the 1-year back rule is going to prohibit any claims incurred before August 6th of 2019. So.
Well, I can say right now, a lot of the year back rules are completely ignoring the fact that the Michigan Supreme Court changed the tolling rules and whatnot so that you can add days on after the June date.
I think if you read the orders speak to, quote, commencement of the action.
Yeah.
And as you know, the 1-year back rule is basically 2 separate rules. One is a statute of limitations, which would be affected by a, quote, commencement of the action order. The second is not a statute of limitations, but is a limitation on recovery and bars recovery of things prior more than 1 year. That would not be affected, in my opinion, by order, quote, commencement of action. So let's see where we are on that one. And let's, Ms. Rhodey, let us send to the plaintiff another copy of the motion for summary disposition based on the 1-year back rule.
Yes, sir. I'll send it right after this hearing.
That way we can get that one out of the way. And then by the time we finish that, and calendar our other motion, we may be in a position where I've got a race judicata situation in terms of the fraud, because by that time we should be in a position where the circuit court will have made its decision on this underlying fraud claim. So let's do it that way.
Okay.
So what might be helpful is, here's my brother. I'm going to schedule for hearing on, let's get you a date. Does June 22nd work for both of you?
I'm not, let me look. I feel like. Yes.
Okay,
And that would work for me as well, Your Honor.
okay. Well, here's what we're going to do. I am going to calendar for June 22nd at 10 o'clock. The plaintiff's, excuse me, the defendant's motion. Where's my calendar? For summary disposition based upon the 1 year back rule only. And then we will calendar, following the decision on that one, the larger one based upon fraud, because it seems to me that may very well be resolved for me by what goes on in the circuit court. And it doesn't make sense in my judgment, since the circuit court would not be bound by anything I do, for me to handle that motion before the circuit court does. Because if
Understood,
they,
Your Honor.
let's say for purposes of our discussion, I ruled one way, that would not be controlling in the circuit court. In contrast, if the circuit court on that same issue and same parties rules way two, whatever way two is, that's going to control me. So it makes more sense to me to do it in that fashion. So that's what we're going to do. So what I'm going to do is I'm going to calendar for June 22nd, 10 o'clock, a pretrial, and there'll be a separate notice of the hearing on the motion for summary disposition based on the 1 year back rule. Now, are you in that circuit court case as well, Ms. Beverly?
No, I didn't know that there was a circuit court case.
Okay. All right. Is there anything else we can accomplish today then?
No, thank you.
I believe we're all set. Thank you, Your Honor.
Okay. June 22nd at 10 o'clock, we will have both a pretrial, and we will hear the defendant's motion on summary disposition based on the 1 year back rule. And then we'll see where we are, because by that time, we should be close to the hearing date. And you should have, who's, for my information, who is the circuit court judge?
Judge Dana Hathaway, Your Honor.
Okay, so I should have a ruling pretty promptly from her. And that date you told me was July 9th?
Yes, Your Honor, July 9th at 8:30 a.m.
Okay, so what you're gonna do when we get together again, you're gonna remind me of that July 9th date with Judge Hathaway. So then we could have probably a relatively short date just for a reporting date, not necessarily a hearing date, a reporting date, what happened in the circuit court. Because it may very well be, it will not be necessary for Ms. Beverly to spend the time filing a response, depending on how that circuit court matter goes. Okay, anything else we can do today?
No, thank you.
Okay. On behalf of all the trees that have died in this file, we'll talk to you on June 22nd at 10 o'clock. Thank you both for coming in. You're off the record.
Have a
Thank
good
you, Your Honor. Have a nice day.
Y'all be safe.
You
You
too.
too.
We are on the record calling file number 21-153834. This file is entitled Gateway Financial versus Wendy Palmer Rose. This file comes to us by way of a change of venue from the 17th Judicial District Court. On April 20th, 2021, court sent notice to the parties of today's pretrial, calendaring the matter for today, May 18th at 10 o'clock. It's now 10:32. Could I have your appearance?
Good morning, Your Honor. Navjot Francis, P72322, on behalf of Plaintiff's Attorney of Record.
Okay, we don't seem to have a defendant. Ms. Palmer Rose has failed to appear. No good cause for that failure having been shown. The court is going to enter at this time the default of the non-appearing defendant. If you would be so kind as to send in your default judgment. This is an account stated, as I recall.
It is, Judge.
With some certain, yeah. Okay, send that in to us and we'll get it entered. Plaintiff is entitled to judgment by default. Plaintiff has appeared, defendant for whatever reason has failed to appear. No good cause that failure having been shown. We are off the record.
Thank you, Judge. For the default judgment, how would the court like that sent in?
Just send it in by snail mail.
Okay, thank you.
Usually I have one in the file, but for whatever reason, I don't have one today.
Okay,
Okay,
thank you.
have a good day.
You too.
Good morning, Your Honor.
Morning, counsel. What brings you here today?
I am here for the motion to reinstate on the Advanced Surgery Center case.
All right. And Mr. Ashton, why are you here today?
Morning, Your Honor. I have just filed in a substitution of attorney on behalf of the city of Detroit.
What file?
I'm sorry, Judge.
What file? I have two city Detroit files at 11 o'clock today, sir.
Right. Let me see. I have minimal, I apologize. I have minimal, I know this is with Jordan, who's also signed in. I don't know that I have a caption on this yet. So I apologize. That's about, it's with tax testing.
How could you have filed an appearance without a caption, Mr. Ashton?
That's, I have it here. It's on tax testing, Your Honor.
I have a Jordan's phone attempting to connect. So maybe he's here on that matter.
He is. I was just talking to him on his cell.
All right, Mr. Ajami, I'm going to put you in the waiting room because apparently I have one case that's almost ready to go.
Okay, Your Honor. I'm going to contact opposing counsel and kind of see where he's at.
I'll be here. All right, who's here on Jordan's phone?
This is Attorney Jordan Leibowitz, Your Honor.
All right, let's call this file. We are on the record calling case number 211493337. Tox Testing Incorporated versus City of Detroit. This appears to be our initial pretrial. Your respective appearances.
Good morning, Your Honor. Jordan Leibowitz on behalf of Plaintiff Tox Testing, P number 75779.
Good morning, Joel Ashton, appearing on behalf of the defendant, City of Detroit.
You remember the State Bar of Michigan?
Yes, sir. P number 47039.
So neither one of you are the attorneys of record on this file. And Mr. Ashton, I understood you to say you just substituted in?
That's correct. I believe we may have just sent that in yesterday. We just received this over this case for defense on Friday, Your Honor. We're just getting up to speed on this PIP provider case.
And what about you, sir?
Yeah, I'm covering for Attorney Mark Gosier. I talked with Mr. Ashton. We need to get him initial disclosures.
Has that been done yet?
No, I told we'll get him to him in the next week.
All right, Mr. Ashton, I am going to need an appearance from you.
Understood. We'll do that today, Your Honor.
Because otherwise I have nowhere to send the notice of the next pretrial. It will go to the attorney of record.
Understood.
I have no discretion in that matter. Now, both of you were supposed to file within 21 days of April 21st, the MCR 2.302A disclosures. And I take it that neither one of you have done so.
That's correct, Your Honor.
Say?
I can't speak to that, Your Honor. We don't have a full copy of this file yet.
So what we have is a waste of time. All right, gentlemen. What I'm going to do, Mr. Ashton, you are going to give me your address and all that information. I'll write it on the new date. Our next date, gentlemen, will be June 22nd at 10 o'clock, at 11 o'clock. Does that work for both of you?
Yeah, that's fine, Your Honor.
What about
Yes, sir.
you, Ashton?
Yes, sir.
June 22nd? At 11 o'clock. And I'll inquire again at that time whether the 2.302A disclosures have been made.
We'll have everything for you, Judge.
I don't necessarily need the disclosure sent to me. You can just
Understood.
send me a copy of the proof of service, for example. But I need for you guys to exchange that information so we can get this PIP case moving.
We will.
Now, Mr. Ashton,
Yes, sir.
Give me your information, please.
Our address is 17436 College Parkway,
17436.
College Parkway,
Okay,
Livonia. 48152,
okay. And what is your bar number again, Mr. Ashton?
47039.
47039.
Correct.
All right, gentlemen, June 22nd at 11 o'clock, we'll have our next pretrial, and I expect by that time, Mr. Ashton's appearance have been filed. I expect the 2.3028 disclosures that have been made, and you gentlemen to have at least taken a look at what you have been given. And we can have some kind of intelligent discussion about what and what is not in dispute. Is there anything else we can accomplish today?
No, Your Honor.
I think that's good for today, Judge.
All right, gentlemen, we'll get this out to you today. Thank you both for coming in.
Okay.
Give me that appearance, Mr. Ashton.
Thank you. Jordan, I'll follow up with you.
Okay, thanks, Joe.
Let's get it
Thanks,
done, gentlemen.
Thank you.
Okay. All right, I'm bye.
All right, we are on the record. This is file number 20165-048, Advanced Surgery versus City of Detroit. This is the motion to reinstate the case filed on behalf of the plaintiff. By way of history, the matter was dismissed by the court following a motion to set aside a default filed on behalf of defendant City of Detroit, the contents of which motion indicated that the court lacked jurisdiction because service had never been properly made. Your respective appearances.
Good morning, Your Honor. Ali Ajami appearing on behalf of Plaintiff Advanced Surgery Center.
Good morning, Your Honor. Crystal Olmsted appearing on behalf of the City of Detroit. Your Honor, I'm standing in for Attorney Raymond.
Grant.
Thank you.
I need bar numbers from both of you, please.
69202.
P84476.
I have Mr. Durant here for some reason.
Oh, did he just come in? He had a conflict, Your Honor. I was trying to,
Let's see if he's here.
okay, well, Mr. Durant is in. I will jump off then.
All right, Mr. Durant, you're gonna take your own file?
Yes, Your Honor. Good morning.
All right, let's call the case again. Goodbye, Ms. Olmsted.
Goodbye, Your Honor.
We are calling file number 20165-048. Case is called Advanced Surgery Center versus City of Detroit. This is the motion filed on behalf of the plaintiff to reinstate the case. By way of history, the court dismissed this matter without prejudice following the filing of a motion for default to set aside default filed on behalf of the City of Detroit. In reviewing that motion to set aside default, it became obvious that there had never been proper service in the matter, and therefore the court lacked jurisdiction. The court granted the motion to set aside the default and dismissed the matter for lack of proper service. Your appearances, gentlemen.
Good morning, Your Honor. Ali Ajami appearing on behalf of Plaintiff Advanced Surgery Center. My P number is 84476.
Mr. Grant.
Good morning, Your Honor. Raymond Garant. Good morning, Your Honor. Raymond Garant on behalf of the City of Detroit, P79349.
Mr. Ajami, your motion.
Yes, Your Honor. We filed the instant motion to reinstate the case. We received a notification that the court dismissed the action for lack of progress. For some reason, there's been some issues with receiving mail from 36th District Court. So some important dates pertaining to this case is that we filed our summons and complaint. We did serve it upon the defendant, and a default, the defendant was defaulted. So back in February, February 5th, 2021, defendant was defaulted, and the defendant did file a motion to set aside that default. So progress was being made on the case. And then for whatever reason, the court decided to dismiss the case for no progress, even prior to the motion to set aside the default. So we're requesting that the court reinstate the case because there are merits to this case that ought to be litigated. And we were making progress on the case. So, we respectfully request that the court consider reinstating the case because in fact, progress was being made as the two parties were working to, deal with this issue of default and kind of coming to a meeting of the minds on where we're at on this case.
Mr. Durant.
Well, as the court's already addressed, Your Honor, the default was set aside because the court found that it did not lack jurisdiction because there was never proper service made upon defendant. So I'm not really sure how that changes as we sit here today.
Yeah, Mr. Jami, I'm having a problem here. If I either have jurisdiction or I don't. I determined when I set aside the default that the default was set aside because the court lacked jurisdiction. How can I reinstate a case in which I lack jurisdiction?
Your Honor, I'm learning today, right now, to my understanding, and I have this here, the case was dismissed for lack of progress. I'm not privy to any order being entered for lack of jurisdiction, for the case being dismissed for lack of jurisdiction. This is new information that I'm learning here on the record, Your Honor.
Well, let's go over.
And that might be part of the problem, Your Honor, is I don't have a copy of the order, and there might be an issue with the mailing from the court to our office. For some reason, it seems like that's the case, because you brought to my attention that an order was entered on defendant's motion, but I don't have copy of their motion, or excuse me, I don't have copy of an order being entered or any notices to appear for a hearing on their motion.
Okay, I do not see a order there. So it appears that I misspoke myself and confused your case with another.
Okay.
The registered action showed that the case was dismissed for lack of progress.
Right, that's consistent.
The problem that I have, let us assume for purposes of our discussion, that it appears that I was wrong and I conflated your case with another, that the dismissal was without prejudice for lack of progress. How do I proceed in a case where I believe I lack jurisdiction over the parties? That is, the default was improperly entered because the court had not been provided with proper proof of service. How do I proceed there?
Your Honor, we did file a proof of service on the complaint. I'm not just quite sure why the court is inclined to believe that there's a lack of jurisdiction. We did file a proof of service for the summons complaint.
The statute provides, Court Rule 2.105G says you make proper service by serving the summons and copy of the complaint on a person in charge of the office and sending a summons and copy of the complaint by registered mail to that officer at his or her address. Your complaint was addressed to Coleman A. Young Municipal Center on Woodward Avenue in Detroit. That is not his office. The Coleman A. Young Center has a city side and a county side, and what? 10 stories on the county side and 14 stories on the city side. That's clearly not consistent with this. So here's what I'm going to do. I'm going to adjourn your motion for 2 weeks. You and Mr. Durant may file whatever supplemental pleadings you wish in regard to this matter. But my problem that I have, sir, is reinstating the case where there was defective service, and that defective service was used to improperly obtain a default. I have a problem with that.
So perhaps let's say we were to correct the service of the complaint. We have no problem litigating the matter. It's not if counsel.
The point. You're missing the point. If I don't have jurisdiction, that ends it right there, unless and until I have jurisdiction.
Okay. So,
The first
Your
inquiry,
Honor, if I may.
Mr. Grant. If you would, sir.
No, I apologize, Your Honor. Defendant is willing to proceed with this matter if plaintiff is willing to stipulate to setting aside the default.
we could do, I mean, we have no objections to that, Your Honor.
All right, then this is what you're going to do. You're going to send me a stipulated order reinstating the case and setting aside the default that was previously entered in this matter. I will give you gentlemen a short return date so we can get this matter back on track. So I would suggest, Mr. Ojami, that you prepare the order to reinstate the case and set aside default, since right now the case is in default, is a dismissed status.
Yes, Your Honor, will do.
Let's give you a short date and get you back here. Let's see if we can't get moving on this file. Okay. How about I have you guys back here on June 1st. Does that work for everybody?
That works fine for my office, Your Honor.
Mr. Grant,
Yes, Your Honor.
June 1st at 11
June
o'clock.
1st, Your Honor.
Did you say that was at 11 a.m., Your Honor?
Yes, like today.
Got it. And then would that just be for a pretrial conference? Is that what that is?
It'll be a pretrial conference.
Yes, sir.
And what I'm going to be looking for at that conference are two things. I want to make sure that that stipulated order has been entered. And I want to make sure that the 2.302A disclosures have been made.
Got it.
Is there anything else we can accomplish today, gentlemen?
So when we return on June 1st at 11 a.m., you're going to be looking to make sure that the stipulated order was entered and that the initial disclosures have been served upon each party.
Correct. Now, don't send me the disclosures.
Right.
I just want to make sure that they have been made, that information has been gone from plaintiff to defendant and defendant's information from defendant to plaintiff. Anything else, gentlemen?
No, Your Honor.
No, Your Honor.
All right, June 1st at 11 o'clock. Thank you for coming in. I'll look forward to the stipulated order, setting aside the default, reinstating the case. And I expect those 2.302A disclosures have been accomplished by the time I see you next.
Okay, and Your Honor, to be clear, should I include in the stipulated order that Mr. Grant, concedes that there's no issues pertaining to jurisdiction?
No, what's going to include is that by stipulation, the parties agree that the default that was entered on whatever it was, date it was, is set aside, and matters and the case is reinstated in general civil docket.
And then Mr. Grant, do you have any issues with stipulating to jurisdiction of the court, or jurisdiction of the court being proper over your client? Basically accepting service. You have a copy of the complaint. So, I mean, if you'd like me to properly service, or are you willing to stipulate to service being proper?
I don't see why that's necessary since we're agreeing to set aside the default and proceed with the case.
Yeah, I guess part of proceeding with the case, I just want to cover my basis, because if we were to do that without accounting for jurisdiction, then you could always file a subsequent motion saying lack of personal jurisdiction. But I mean, we could avoid that runaround just by stipulation.
If he has.
Go ahead. Sure.
All right. Now here's the other thing.
Yeah.
Going forward, a little more attention to the court rules. The rules
Yes, Your Honor.
are relatively specific. And to say I served somebody in a building that's got 2 sides and multiple stories, just ain't cut. All right,
Yes,
Joe,
Your Honor.
work this language out amongst yourself. We'll be together again June 1st at 11 o'clock. Stipulated order entered, 2.3028 disclosures made. Anything else, Joe?
No, Your Honor. Thank you very much.
Mr. Grant? All right,